So this is surrender week for Donald Trump, as well as the 18 others charged with racketeering in Georgia for plotting to steal the 2020 election. They'll have just over 3.5 days until noon on Friday to surrender at the Fulton County Jail to avoid facing arrest. We just learned that the ex-president says he will surrender in Atlanta on Thursday. Today, his lawyers were at the Fulton County Courthouse, where his bond was set at $200,000. Let's just sit with that for a second. By the end of this week, the ex-president of the United States will be out on bond in yet another jurisdiction. Fulton County District Attorney Fani Willis is also trying to stop Trump from continuing his practice of making direct or indirect threats, or both, against people involved in his various criminal cases. She ordered him to, quote, perform no act to intimidate any person known to him or her to be a co-defendant or witness in this case, or to otherwise obstruct the administration of justice. That includes no threat of any nature against any co-defendant, against any witness, against any victim, or against the community. And it makes clear that this applies to, quote, posts on social media or reposts of posts or retweets, if you want to call them that, made by another individual. Some of Trump's 18 co-defendants also got bond orders today as well, but Trump is so far the only one with these detailed orders against making threats. I wonder why. All of this comes while the ex-president and his legal team are navigating 3 other indictments, and the possibility that some of his co-defendants in Georgia may have a big incentive, a huge incentive, to cooperate against him. For one thing, Trump can never pardon any of them, even if he returns to the White House, because this is a state case. And of course, all of this is just a fraction of his current legal problems. Glenn Kirshner is a former federal prosecutor and host of the podcast Justice Matters. Ankush Khardori is a former federal prosecutor and a contributing writer for New York Magazine, and both join me now. So, Glenn, I just wanted to start with these kind of warnings from the judge, because that is very strong language. We've heard it in some of these other cases. But what can she actually do, and what do you think she should do if he violates it?
You know, I don't think Fani Willis owns a pair of kid gloves. So I have a feeling if Donald Trump violates these conditions, and how could he not, Jen, right? He can't post or repost anything that might be intimidating of a witness. Not just a week ago, he did something that if he did it now, it would be prohibited by this order. He said, look, I know that former Lieutenant Governor Jeff Duncan is about to testify before the grand jury, quote, he shouldn't.
He's already violated it, essentially.
He would have.
He would have,
yes. And interestingly, that actually constitutes a violation of Georgia state law. And that could be used next week by Judge Chutkan up the street to say you did violate a condition that had been set
coming
for
up
you.
Next Monday. And we were just talking before during the break, I guess, about what the actual conditions or what are the consequences if your name is not Donald Trump, which is important to remember as we discuss equal justice under law. So if somebody else did this, what would happen to them?
Well, actually, we have a pretty good example that has been in the news recently. Sam Bankman-Fried was charged for a massive fraud. Yeah. He was out on bail, and prosecutors alleged, and the judge agreed, that it appeared that he was attempting witness intimidation by kind of working through the press to seed some negative information about a cooperator. He was remanded. That means he was sent to jail. The judge was not happy about it, obviously, but that's what often happens to defendants who are out on bond. Honestly, in the ordinary course, it can be quite easy to violate terms of release, almost like a tripwire, and Trump is sort of getting a lot of benefit of the doubt.
You also had something you wrote interestingly recently, that the addition of defendants creates pressure and incentives for those people to cooperate against the biggest target, which in this case is clearly Trump. I referenced, of course, in Georgia, he can't pardon them. What are the other incentives?
Well, I mean, there's the traditional set of incentives, and this applies at the federal and the state level. Anytime you have a large multi-defendant case and there's a lead defendant, right, and Trump is undoubtedly the lead defendant here, right, there's an incentive for everyone else who might have information on him to try to cooperate against that person to get cut themselves a break at the end of the day. It's purely self-interest. It's not an act of altruism, right? They've been charged, and if they need to be sentenced one day after a conviction, they're going to want all of the credit and goodwill that they can generate with prosecutors. So that tends to be the normal calculus.
So, Glenn, there's been a whole back and forth about the timeline here. That's a very diplomatic way of saying this, given Trump's team has asked for a trial in 2026. Jack Smith's team replied and said that's bogus. That date is going to be set, or we expect that date to be set, coming up next Monday. What do you think is going to happen here? What's kind of a viable timeline for a trial?
Well, let's look at what Judge Chutkan said previously. She said, if the defendant continues to say things, to post things that might interfere with our ability to pick a fair and impartial jury, might poison the jury pool, might intimidate witnesses, I will accelerate the trial date. He has done some of those things. So I have a feeling Judge Chutkan is going to set a trial date in early 2024. I also think when the defense team, Trump's defense team, throws out a date that's 2.5 to 3 years down the road, April 2026, it sort of shows that they're not really engaged in legitimate lawyering. I mean, it really feels like they're assistant campaign chairman at this point for Donald Trump.
Ludicrous a little bit.
And that will help, I think, push Judge Chutkan to an earlier trial date if they're not really trying to legitimately present a trial date that, you know, is an honest assessment of how much time they think they're going to need. So I can't wait until next Monday. I want to see what Judge Chutkan does. But I think she understands that everybody, including the American people, have a keen interest in getting this case resolved well in advance of the 2024 election.
Do you agree on the timeline, early next year?
I do agree if it's feasible. I mean, I think out of all of these cases, I think the strongest imperative by far concerns the January 6th, federal January 6th case and bringing that case to trial, ideally as quickly as possible. And I also agree that, you know, the setting of a trial date, anytime you have kind of litigation and competing positions of parties, can be a bit like settlement or like a bid and ask sort of scenario, right? Prosecutors have put forward a date. Trump's lawyers have put forward a date that's so absurd that I think Chutkan will just set it aside, or it's very probable she'll set it aside, and that really sort of the main kind of center of gravity is going to be the prosecutor's proposal. I have no idea how it will be resolved, but she does seem to have a keen awareness of the significance of this case and its importance to the country.
Before I let you go in my legal education this evening, I wanted to ask you about Mark Meadows, because there's a range of reporting about him cooperating, not cooperating, sharing information, not. We don't entirely know the totality of it. But for each of you, and I'm going to start with you, Glenn, what's the best case scenario for Mark Meadows?
You know, he's in such a curious posture right now. This is like an action-adventure legal thriller, because all indicators were that he was cooperating with Jack Smith in the federal case, both in Washington and in the documents case in Florida. And then all of a sudden, he pops up as a charged RICO defendant in Georgia. Now, I will say, when I had defendants and they had criminal exposure in multiple jurisdictions, I worked very hard to try to strike a global plea agreement that would resolve all of their criminal exposure so we could kind of keep our cooperator close. That doesn't seem to be the case right now. So it feels like maybe he is helping Jack Smith. Maybe he has not yet formalized a cooperation agreement. And Jack Smith has said, until that happens, you just go ahead and take care of your own little problems down in Georgia, and maybe we'll circle back on that.